Welcome once again to Lehto's Law. Here's Steve Lehto.
Caleb sent me a note about a story, and this is a crazy one. Jurors using Google caused a mistrial in a murder case. Sarah Jean Green wrote this to the Seattle Times. A King County Superior Court judge didn't mask his frustration when he declared a mistrial after learning a handful of jurors had used Google to do research about the murder case they were deliberating in Kent. The judge said, at its core, I have jurors who either lied to me or blatantly disregarded the admonishments that I have done on a daily basis, he told the deputy prosecutor and defense attorney who were trying the case, according to transcripts of the court proceeding. I see no other alternative than a mistrial. They know damn well they were only supposed to consider what was presented in this courtroom, and they didn't. The right to an impartial jury is one of the several rights guaranteed under the Sixth Amendment for people facing criminal prosecution. One of the ways judges ensure impartiality is by instructing jurors at the beginning of a trial, before every break or recess, not to speak to anyone about the case, to refrain from doing any outside research, and to avoid newspapers and TV newscasts if it's high profile, so they don't inadvertently expose themselves to information that hasn't been admitted for trial. Jurors are told they must base their deliberations solely on evidence presented in court, which is subjected to cross-examination, overseen by a judge who determines what information is properly before the jury. Admissibility. With internet research, there's no one to challenge the information or establish its veracity, potentially disadvantaging one side or the other. While misconduct by a single juror occasionally happens, that can be remedied by dismissing that juror and bringing in an alternate. But for the entire jury panel to be tainted is unusual, said the chief criminal deputy prosecutor in the King County Prosecutor Attorney's Office. In my experience, very few cases have resulted in a mistrial due to juror misconduct issues. Most jurors take very seriously the instructions of the judge, and fellow jurors are often in a good position to ensure the judge's rules are followed. So the case involved a crime that took place back in 2021. The defendant is claiming self-defense. The trial began in July, and a 15-member jury, which is 12 plus 3 alternates, but you don't know who's who until they start deliberating. There were opening statements. The jury began deliberating on July 31st. 2 jurors had been excused for health or work reasons. 10 minutes after the jury was dismissed for the day on August 7th, a juror called the bailiff and reported that another juror had been researching post-traumatic stress disorder on his phone during deliberations. After consulting with the state and the defense, the judge questioned jurors individually, asking if they'd done any outside research about the case. And also if they were aware of any other jurors doing research, and if yes, whether any information had been shared with other jurors. All 12 denied doing outside research, but 2 said they knew of others who had done it. So you have a problem right there. So there was more questioning done, and then finally it came out that 4 jurors had used Google to look up post-traumatic stress disorder, street views of the apartment complex, and other information about the scene of the crime. At that point, the defense attorney filed a motion for a mistrial. And the story is quite lengthy, and I'm not going to get into all the details of it, but let's just stop it right there. So you get an instruction that says, do not do any of your own research, don't watch the news, don't read the newspapers, don't talk about this with anybody. Well, going on your phone and doing research is doing research. Now, I know that some people are going to say, but Steve, come on. Everybody knows that, I don't know, if somebody were to say, hey, do you know what a 1953 Chevy pickup truck looks like? Rather than stammering for a few minutes trying to remember, you just Google it and you get a picture in 2 seconds. That's what it looks like. But the problem is, when you've been told not to do that kind of stuff, you shouldn't do that kind of stuff. Because, now here's the part that's going to blow a lot of people's minds. The internet is occasionally wrong, and the court is very clear that what you're supposed to deliberate is the facts that were presented in court. In court. And so there very well could be a reason why there is something missing from the case. And that's the kind of thing that I've heard people say. Both the prosecution and the defense missed something. They missed this big thing. They missed this thing. Turns out the thing that was missed was not missed and had been the subject of pretrial motions. And it turns out that there's a very good reason why that thing that you thought was missed was left out. And so you have to just have faith in the system and say, okay, the prosecution's over there, the defense is over there, and the judge is up there. And you know something? We're going to deliberate what's before us. And I know the temptation would be there. I know it would be. And I know that, I was recently skimming something, and I saw that there was an accident at an intersection. Intersection I've driven through a lot of times. But I couldn't remember off the top of my head exactly which buildings were there. You go to Google Maps, pull it up, Earth view, zoom in. You can look at the buildings, street level view, overhead view. You can see all that stuff. So you might say, what's the problem with looking at that? Okay, let's suppose that, and this is a murder trial, but let's suppose there's a car accident, and one of the parties says, I couldn't see because of the way the intersection is laid out. That becomes an issue, and you're there to decide whether or not it's reasonable that a person would say, I couldn't see because of the way the intersection is laid out. There's something funny about the intersection. Some people testified that there was indeed something off about the intersection. Other people said no. So you go to Google Maps when you're not supposed to, and you zoom in overhead view, and let's assume you've never been at the intersection. And let's say that you then go to the street level and look around. How do we know that those photographs you're looking at right now show it exactly as it was on the day of the accident? Some of those photographs on Google Earth View are a little bit older. And some of the street view photos, likewise, might be older. Were they shot before or after the accident? And those kinds of foundational questions should have been answered if that stuff had gotten into evidence. So if somebody comes in and brings in photographs of the intersection, puts them up in front of the jury, and they all get admitted, part of the admission process is somebody explaining what the photograph depicts, whether it's accurate or not, when the photograph was taken, and if there's any changes between then and now. Those kinds of things are brought in, and they're there for the jury to understand. When you start looking at random photographs on the internet to get a better understanding, it's going to be a problem. So, unfortunately, a mistrial was declared, just wasted all these people's time, judicial resources. They got to start over now. And what they're going to have to do going forward is literally adjust the jury instructions and say, you are not to do any outside research. You're not to discuss the case with anybody. You can't watch coverage of it on the news, listen to it on the radio, read about it in the newspaper if you know what those are, and can't talk about it with your friends. Don't even talk about it amongst yourselves until you begin to deliberate. They actually tell you that. When the jury is excused for the day, on the way to the courtroom, you don't discuss the case. And they're going to have to say this, don't Google it, don't look anything up. I've heard of cases before where somebody was so curious about something that in the evening when they gotten out of court for the day, they went and drove by the scene, whether it's the crime scene or something else. They went and drove by. You're not supposed to do independent research. That's something else you'll be warned that you are not to do. And again, you might say, but Steve, what's wrong with me going to the crime scene? The crime scene might be different today than it was 3 years ago. There's a very good chance it is. And how would you know that? By going to look at it? And you might say, but Steve, what if I, as a juror, cannot make a decision without going to the crime scene? You send a note to the judge through the bailiff that says, some jury members are concerned that we don't quite understand enough about the crime scene. We would like to see it. Is that possible? And there have been occasions where they take a jury out to a crime scene. but they do it in an organized fashion. But it also gives the attorneys an opportunity to argue about it, whether or not that's appropriate. Because what if the crime scene has been changed? Because this murder took place in 2021, if it was a murder. A jury's going to decide. But the incident that gave rise to the trial happened in 2021. Did anything change in those ensuing 4 years? Quite possibly. So if something did change, then you have a choice. Bring the jury out and explain to them, by the way, things have changed, here's how, but you have to have a witness do that. Or you have to send a note back and say, we're sorry, but we cannot do that. You should deliberate with the facts you have. And so keep in mind what I said earlier, that the jury doesn't always have all the facts, and sometimes there's a reason for it. And so I've often seen it where a judge will tell a jury, if you want to, you can stick around. If you don't want to, you don't have to. But when the case is over and the verdict's been rendered and you've been excused, you can stick around and talk to the attorneys and talk to the court. And it's not uncommon. They have these debriefing sessions afterwards. I've seen jurors go, excuse me, can I ask a question? How come nobody mentioned such and such? I've seen it where one of the attorneys looks at the other attorney and goes, want me to tell him or you want to tell him? And then they explain the reason why something obvious had been left out. And there'd be a reason for it. And so you're not supposed to speculate about things that aren't in evidence. You're not supposed to research things that are or research things that aren't. You're not supposed to be doing that kind of stuff. So it caused a mistrial here. But, juries, I love juries. And I know a lot of people say, but Steve, I would never want to serve on a jury. I hate serving on a jury. I've been called so many times. I hate it. And I always say, yeah, but if you got arrested on bogus charges and you were facing a court for your life, your freedom, whatever it might be, do you want a judge deciding that? Or do you want a jury deciding that? And next time you get a jury notice, because I've gotten a few of them myself, remind yourself that you yourself would probably like a jury somewhere down the road, and you'd like people to show up. So that's part of your duty as an American. It's in the Constitution. You're entitled to a jury trial. Well, that requires people to show up for jury duty. Caleb, thanks for sending that. That is from the Seattle Times, and Sarah Jean Green wrote it. Googling jurors caused mistrial. 2021 murder case that happened up there in King County. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Ambition is a poor excuse for not having enough sense to be lazy.